Hello, this is Scott, and today I will be addressing hypothetical question number 3 in our 8th workshop on interstate trade. So to start with, I want to start with the facts of the case. And to start with the facts of the case, first let's identify the parties in this case. This concerns two milk suppliers. One of these milk suppliers is a local New South Wales milk supplier called the New South Wales Milk and Dairy Board, which supplies milk to shops in New South Wales. The other one is an out-of-state supplier based in Queensland that supplies milk to both Queensland and New South Wales. So Queensland Milk Limited engages in interstate trade, whereas New South Wales Milk and Dairy Board engages in intrastate commerce. And what's interesting about these two, while they provide the same service, same product, is there are two pieces of legislation that treats them very differently. So we're going to look at those provisions in the legislation and whether or not they would be valid in the spirit of Section 92 of the Australian Constitution. And those two pieces of legislation, the first one is the Dairy Industry Act of 2019. And this is a New South Wales law that stipulates that all interstate milk suppliers must be licensed upon the payment of a registration fee. Now, the purpose of this act is to make sure that milk that is coming from out of state is safe and to their satisfaction is safe for the public to consume. And they do this by creating the Dairy Industry Authority to issue these licenses. So obviously in New South Wales, it's governed and regulated in a certain way. But if you're getting milk that comes from WA, Queensland, Victoria, you want to be sure that they're up to the same standards as the stuff that you're producing in state. So they have this regime where, you pay a fee, you get vetted, you get a license. The interesting thing, though, is it does not impose those fees on local suppliers. So it does not impose it on New South Wales Milk and Dairy Board, but it does impose it on Queensland Milk Limited. The second piece of legislation we're looking at is the Bottling of Dairy Products Act of 2013. And this act says that all milk coming from interstate or coming from out of state must be contained in glass bottles. Seems like a reasonable thing because they want to reduce littering. And if you have plastic, paper carton bottles, those things might be littered all the time, aren't as easy to recycle perhaps. So they have an environmental concern for mandating glass bottles. But like the Dairy Industry Act of 2019, they treat local suppliers different than out-of-state suppliers, because while interstate suppliers must package their milk in glass bottles, intrastate suppliers get to choose whether they package it in glass bottles or paper cartons. And paper cartons are cheaper to produce than glass bottles. And in effect, what this does is it imposes an additional cost on out-of-state suppliers, giving local suppliers an unfair advantage because, of course, cost difference in production. And so what this does for our two parties here, the Queensland Milk Limited and New South Wales Milk and Dairy Board, is one of these suppliers doesn't have to pay registration fees to get a license, and they can elect to package their milk in cheaper containers. And the other one, has to pay a fee, and they've not registered under this New South Wales law. And what happened to them is they were banned from carrying out business in New South Wales. And the effect of that is New South Wales Milk and Dairy Board saw an increase in their business due to relative lack of competition. So the questions we're going to ask ourselves in this hypothetical is, are these provisions of the Dairy Industry Act of 2019 and the Bottling of Dairy Products Act of 2013 constitutional? Not the acts themselves, but specifically the provisions of the acts that lay out the requirement for out-of-state vendors to use glass bottles while allowing in-state vendors to opt for paper cartons and glass bottles, and the requirement for out-of-state vendors like Queensland Milk Limited to pay registration fees and licensing fees, but give out-of-state vendors like New South Wales Milk and Dairy Board a pass. And to answer these, we're going to look at Section 92 and apply the test in the landmark case Cole and Whitfield. So first of all, what is Section 92? Section 92 states, on the imposition of uniform duties of customs, trade, commerce, and intercourse among states, whether by means of internal carriage or ocean navigation, shall be absolutely free. So what does this mean? In effect, Section 92 prohibits the discrimination or discriminatory burdens on trade of a protectionist nature. However, though, there are exceptions, as there are to many rules, and discrimination is allowed if the law has a legitimate non-discriminatory purpose. So in this question, we're asking ourselves, one, are these laws discriminatory and protectionist? Do they put a burden on interstate trade, which is fairly straightforward for all three of those questions. But the fourth question we ask ourselves is there a non-discriminatory purpose that might justify it? So starting with the Cole and Whitfield test, the Cole and Whitfield test asks three primary questions, and it asks a fourth secondary question to the third question. So the first question it asks, number one, is there a burden on interstate trade? Number two, is the burden discriminatory on its face or in its practical effect against interstate trade? Three, does the law have a protectionist effect? It could be protectionist in law or in fact. And if it is protectionist, is that protectionist effect incidental to a non-protectionist purpose? And we look at the issue of proportionality. Is the law appropriate and adapted to achieving that purpose? So let's start with the first question in the Cole and Whitfield test. Is there a burden on interstate trade? Clearly, yes, because the glass bottle requirement restricts the type of product that can be sold and imposes an additional cost on suppliers, as glass bottles are more expensive than other types of containers, such as paper cartons and plastic bottles. On the licensing fee, obviously, yes, as well, simply because it imposes an additional cost to do business. Second question. Is this burden discriminatory? Now, if it was applied across the board, if New South Wales says, we are going to treat out-of-state vendors the same as in-state vendors, you could argue that it is not discriminatory, and you'd be right. However, this burden in its effect, is it discriminatory on its face and in its practical effect? Absolutely. Because one, with the licensing, the fees are imposed on out-of-state suppliers like Queensland Milk, but they are not imposed on local suppliers. This is blatantly discriminatory against out-of-state vendors. Secondly, the glass bottle mandate, that is also discriminatory because it imposes a regulation on out-of-state vendors that is not imposed on local providers. So that gives them the option of having cheaper production and getting a comparative advantage. Third question is the law protectionist? Or does it have a protectionist effect? And fundamentally, yes, because if it is given a comparative advantage to an in-state supplier, absolutely. And the case of Bath and Alston Holdings held that a protectionist law either confers an advantage on a local product or removes an advantage from an interstate product against a local product. And both the licensing fee and the glass bottle mandate effectively confer an advantage on the local product at the expense of out-of-state suppliers. And it confers that advantage by imposing an expense on out-of-state suppliers. So we have yes across the board for the first three questions. But now that we've established that these laws are protectionist, is there a non-protectionist purpose that's compelling enough? So is that protectionist effect incidental to a non-protectionist purpose? And when we look at the reported reasoning, the statutory intent behind the glass bottle mandate, it was to reduce litter. But giving local suppliers the option to use paper cartons does not do that in a non-discriminatory manner. And it does not effectively do that either, because if you're thinking about litter and you're a consumer and you go to a local store and you don't really know the difference between an out-of-state supplier versus an in-state supplier, you buy a carton of milk and you decide to litter it. Does it matter if it came from an out-of-state supplier or an in-state supplier? You reasonably know it doesn't. So this is discriminating for the sake of it and doesn't have any real practical effect to achieving its alleged statutory intent. If the ban included local suppliers, perhaps, this would be valid, but it doesn't. The registration fees being imposed on out-of-state suppliers, but not in-state suppliers, also does not serve any protectionist purpose. So we look at proportionality, like, is the burden proportionate to the achievement of the legitimate purpose? And in this case, it is not. So when we look at the interests of these laws, for licensing, it's public health. That's a legitimate interest. For the glass bottle mandate, it's reducing litter and environmental concerns, which is also a very compelling and legitimate interest. But these policies are not applied uniformly. They're not applied across the board. These burdens aren't. So they are applied in a discriminatory fashion, and that undermines their validity and, in effect, is a fundamental breach of Section 92. So per the Cole and Whitfield test, we can conclude that both of these laws are in breach of Section 92. Now, that is my answer for question 3. The discussion questions I want to include in this workshop as well. First one is to discuss the Palmer and Western Australia case and its implications for interpretation of proportionality in Section 92. This is a recent case that had to do with border closures during COVID. WA obviously had a much more stringent border protection than other states did, or they at least were slower to open up. And that had a real effect on interstate commerce. Clive Palmer challenged that. He was not ruled in his favor ultimately, but I want to take a look at that and look at Section 92 from a more contemporary and relevant purpose. I think that would be an interesting question. The second one is I want to discuss what the majority's reasoning on Bath and Alston Holdings was. This is a case where Victoria imposed a 25% tax on out-of-state tobacco products, but did not tax in-state tobacco suppliers. However, to account for that, they imposed a 25% tax on wholesalers. And so they reasoned, well, we're imposing 25% tax somewhere or the other. And the court had to answer, does this effectively constitute a protectionist policy? Spoiler alert, they found out they did, because for the simple fact that out-of-state suppliers might be imposed to a similar tax on wholesalers in their own state. But we want to look at that and analyze how does this affect our understanding of the test for whether something is inherently protectionist. And thirdly, I want to look at how might the High Court's interpretation and application of Section 92 change in the future with technological advances in a more globalized world. Do you think it will, or will Cole and Whitfield hold as the law for the foreseeable future? Obviously, our understanding of Section 92 has changed over the course of its existence. Prior to 1988, it had more individualist approach, and there's a more free trade approach post Cole and Whitfield. It's been almost a quarter century since Cole and Whitfield. So going forward in a rapidly changing country, in a rapidly changing world, will that interpretation hold up, or will the High Court, are there any cases that the High Court has dealt with so far that might suggest they might amend their interpretation and understanding of Section 92? Anyways, that's my presentation for workshop 8, hypothetical question number 3. Thank you so much.